I'm sorry, Yogi Adityanath ji. Here then, ladies and gentlemen, are 8 reasons why Hindus are 8th class citizens in their own country. The third reason, 3, the Waqf Act 1995. Waqf is the third largest landowner in India after defense and the railways, with much of its land holding rather amusingly pre-independence, an endowment of the insidious give and take between the British and the Muslims they desired to pacify. Indeed, many of the Waqf land holdings go as far back as 1857. 77% of Delhi is on Waqf land. I had to really practice repeating this Waqf time and again. I didn't want to make a mistake there. Including the Delhi High Court, Central Vista, that has recently been renovated and on whose hallowed turf new government buildings will shimmer and glisten, is on Waqf land. CGO Complex, Jawaharlal Nehru Stadium are on Waqf land. Only 3 things are certain in an Indian's life: death, taxes, and that knowingly or unknowingly he ends up walking every day on Waqf land. Over time, many of these Waqf properties were taken over by the government, but then inexplicably, or perhaps not, one of the last decisions of the outgoing UPA government in 2014 was to gift 123 prime central Delhi properties to Waqf and withdraw its claim on them. These prime real estates properties are from the time of our independence and were endowed to the government by the departing British. Their status remained unchanged for 70 years until March 5, 2014, when the departing Congress decided to endow them to the Waqf. Even the High Court judges have opined that Waqf land is Allah's and Allah's alone, and that the government cannot be the owner of this land. It is not just government buildings that the Waqf claims to be its properties. Mukesh Ambani's house is on Waqf land. It is worth checking whether this hall where I am delivering this lecture is also a Waqf property. Allah is all merciful. Please check. The Waqf board lays claim to 354,913 estates and 866,035 properties comprising 802,000 acres of Indian land, with UP having the highest share of 213,833 Sunni Waqf board properties and 15,386 Shia Waqf board properties. हिंदू मुस्लिम गंगा जमुना यूनिटी तो बाद में संभाल लेंगे, यहाँ तो जमुना भी शिया सुन्नी में अलग अलग बट गई है. This data, by the way, is from the Waqf Management System of India, whose motto, if you visit their website, is once a Waqf, always a Waqf. Hold your horses, you Hindutvawadi Islamophobic bigots. You will, if you were to dig deeper, find that this grandiose motto is not the idea or thinking of the Waqf board or any of its members. It is, in fact, the verbatim exclamation of the Supreme Court in its 1998 judgment, case number 4372 SCR 398. Once a Waqf, always a Waqf. And the name of the honorable judge who said this iconic line, I'm not joking, Justice Dr. Anand. Allah is all merciful. Waqf essentially means that any donated property belongs to Allah in perpetuity. Waqf decides any property adjudged by Muslim law as pious, religious, or charitable, and therefore fit to be labeled as Waqf. In other words, Waqf is inalienable and irrevocable. If you think this is a figment of my fertile imagination, let me quote directly from a Waqf board document. Quote, Waqf is a voluntary, permanent, and irrevocable dedication of a portion of one's wealth, in cash or kind to Allah. Once a waqf, it never gets gifted, inherited or sold. It belongs to Allah and the corpus of the waqf always remains intact. The fruits of the waqf will be utilized for any Sharia compliant purpose, unquote. The waqf boards are, in case you were wondering, headed and constituted exclusively by Muslims. If that wasn't discriminatory enough, let me run you through some sections of the Waqf Act 1995. Section 4 bestows on the Waqf property survey commissioner the authority and power like that of a civil court. Besides, the entire cost of the surveying is to be borne by the state. So, in a sense, a Hindu's property once declared as Waqf property wholly arbitrarily will be surveyed by Waqf, and the cost incurred on this count will be paid for by the Hindu taxpayer. And people say we are living in a fascist Hindu Rashtra. Kyun mazak kar rahe hai? Section 40 gives the Waqf power to decide if your land is Waqf or not. In fact, if your property is laid claim to by Waqf, it is your responsibility to disprove its claim. And till such time you disprove it, it is Waqf land. Quote, where the board has any reason to believe that any property is Waqf property, the board may hold an inquiry in regard to such property, and if after such inquiry the board is satisfied that such property is Waqf property, call upon the owner either to register such property as Waqf property or show cause why such property should not be so registered as Waqf property, unquote. Section 54 gives the Waqf the the power to declare you an encroacher. Quote, whenever the chief executive officer considers whether on receiving any complaint or on his own motion that there has been an encroachment on any land, building, space, or other property which is said to be Waqf property, he shall cause to be served upon the encroacher a notice specifying the particulars of the encroachment and calling upon him to show cause before a date to be specified in such notice as to why an order requiring him to remove the encroachment before the date so specified should not be made, and if, after considering the objections received during the period specified in the notice and after conducting an inquiry, the chief executive officer is satisfied that the properties in question is Waqf property and that there has been an encroachment, he may make an application to the Waqf tribunal for grant of order of eviction for removing such encroachment and deliver possession of the land, building, space or other property encroached upon the Waqf. The tribunal, upon receipt of such application, will make an order of eviction directing that the Waqf property shall be vacated by all persons who may be in occupation thereof by any part thereof, provided that the tribunal may, before taking an order of eviction, give an opportunity of being heard to the person against whom the application of eviction has been made. If any person refuses or fails to comply with the order of eviction within 45 days from the date of eviction of the order, the chief executive officer or any person duly authorized by him in this behalf may evict that person from and take possession of the Waqf property. समझ में भी कुछ नहीं आया और सुन के भी अच्छा नहीं लगा. So let me get this straight. The Waqf decides in its wisdom that a property is Waqf property. It then serves a notice to the encroacher. Subsequently, it takes the matter to the Waqf tribunal, headed by all Muslims. And the tribunal decides on the nature of the said property and orders eviction. The terror continues paragraph after paragraph, section upon section. Let me read out section 85, bar of jurisdiction of civil courts. Quote, no suit or other legal proceeding shall lie in any civil court in respect of any dispute, question or other matter relating to any Waqf property or other matter which is required by or under this act to be determined by a tribunal, unquote. Bravo. In fact, even the Supreme Court declared in 2019 that a civil court in India has no jurisdiction in the matter of a suit pertaining to a Waqf property. Let me remind you of the ground reality. All this legalese is fine, but the ground reality is that Waqf tribunal decision can only be overturned by a long and financially draining legal process. That is only possible in the recent times. Earlier, you couldn't even do that. The Waqf knows this. In a country where 40 crore cases are pending, harassment through legal procedure that stems from the inner offices of an all-appeasing government, executive and judiciary, is a sword that is sharper and more potent than Khalid's. How, one may then ask, has the Waqf Act 1995, that is patently unfit to be applied to leave alone a mental asylum, has been applied to a nation of 1.3 billion people, assuming the two are not one and the same? Remember, there is nothing in the act that safeguards the religious properties of Hindus being appropriated by the Waqf. This itself violates not only the principles of natural justice but also multiple articles of our constitution beginning from 14, 15 and 25. In fact, BJP's enfant terrible, Ashwini Kupan Upadhyay, who will figure a lot in my lecture, recently filed a petition in the Supreme Court challenging the validity of the Waqf Act. His plea was that the Waqf Board has Muslim MPs, MLAs, legislators, civil servants, lawyers, scholars as its members, and they are remunerated by the taxpayer, even though the state doesn't collect money from mosques. How is this secularism, he asked. The Supreme Court refused to entertain the plea and threw it out. The judge called the petition, quote, abstract. That judge is now and will remain for the next many years the Chief Justice of India. The mayhem continues. Here is section 28 that outlines the power of the district magistrate, additional district magistrate and subdivisional magistrate to implement the direction of the Waqf Board. Quote, subject to the provisions of this act and the rules made thereunder, the district magistrate, or in his absence an additional district magistrate, or in his absence a subdivisional magistrate of a district in the state shall be responsible for implementation of the decisions of the board which may be conveyed to the chief executive officers, and the board may, wherever it considers necessary, seek directions from the tribunal for the implementation of its decisions, unquote. What was it that one of the main protagonists of Vivek Agnihotri's film said? Government bhale hi inki ho, system to hamara hai. Well, सिस्टम ही नहीं, यहाँ तो डिस्ट्रिक्ट मैजिस्ट्रेट, एडिशनल डिस्ट्रिक्ट मैजिस्ट्रेट, सब डिविजनल मैजिस्ट्रेट भी हमारे लगते हैं. दिल नहीं भरा लगता आपका. Well, here then is section 107. Now in law, there is something called the statute of limitation. That is, the time period for acting on a dispute or filing of a suit is set by law. And this law is enacted through the Limitations Act 1963. But wait, section 107, quote, Act 36 of 1963 will not apply for recovery of Waqf properties. Nothing contained in the Limitation Act 1963 shall apply to any suit for possession of immovable property comprising in any Waqf or possession of any interest in such property, unquote. What this means is that the Waqf can lay claim to and recover any property it wishes to without having to worry about the passage of time. After all, time hai kya? The Waqf, as you would have realized by now, is a parallel government, wholly sanctioned by our own government. It has, through its overarching board, its own legislature, through its surveyors and estate and compliance officers, its own executive, and through its tribunal, its own judiciary. And through this act, through its application, a message is sent to every citizen of this country. We are a special people. And that message is all pervasive and uncompromising. And it is this message that allows Muslims, even rational and logical and educated Muslim, to claim that the Gyan Vyapi mosque built atop the Grand Kashi Vishwanath temple is on Waqf land. So, was the Grand Kashi Vishwanath temple demolished by the genocidal monster Aurangzeb, and as confirmed through his own certified biography, Masir-e-Alamgiri, also on Waqf land? Is this the message that allows Muslims, even rational and logical and educated Muslims, to claim that the 1500-year-old iconic Manandiya Vali Chandrasekhara Swami temple in Tamil Nadu is on Waqf land? I ask you, How can a 1500-year-old Hindu temple be adjudged by Waqf to be on Islamic land when Islam is only 1300 years old? How? गंगा जमुना तहसीब बोल बोल के गंगा भी ले ली और यमुना भी ले ली. The more you read on Waqf, the more you realize that bulk of its muscle is flexed not only through the draconian Waqf Act, but also through a letter that Prime Minister Indira Gandhi wrote during the emergency, ordering all states to strictly obey her diktats. If the Waqf properties, she wrote, have gone into adverse possession of state government departments, the Waqf board could well start legal proceedings against the concerned departments. And where costly buildings have been put up by the state on Waqf land and their vacation is not feasible, the state government may enter into permanent leases with the Waqf board after paying to the board the bulk of the market value as premium. I understand, she further wrote, that Waqf boards have sent your governments lists of Waqf properties in the possession of government departments. Please see that these are dealt with as suggested above. A periodic review should be undertaken and a monthly report sent to me. Waqf, as ordained by the committee and as agreed to by the center, should be treated differently from individual landlords and therefore exempt from the Rent Control Acts. The Waqf only asked the Congress to bend. The Congress decided to crawl. In fact, during the dying days of the UPA, the Waqf Properties Eviction of Unauthorized Occupants Bill 2014 was tabled in the Rajya Sabha, giving draconian and overarching powers to the Waqf eviction officer to demolish whatever it considered as an encroachment of Waqf property. I am sorry, Yogi Adityanath ji, but read this bill. It is the humble Waqf estate officer and not you who is the original bulldozer Baba. Through this tabled bill, not only was every order made by the Waqf estate officer to be considered final, it could also not be called into question in any original suit or application, and no injunction could be granted by any court against it. But things didn't just stop at injunction. The bill barred any Indian court to have jurisdiction to entertain any suit concerning the eviction of any person from any Waqf property or demolition of any structure or fixture from any Waqf property. ये लिखता कौन है ये ऐसी legalese? I would really love to meet that guy. Luckily for us, encroachers of Allah's land and that hard Congress went away in 2014 and was replaced by the soft Congress. Appeasement continues, if not through this draconian bill, at least in the interim through the 1995 Act. That the Waqf Act 1995 is blatantly communal, discriminatory, unconstitutional and draconian is not in contention. One only must read its clauses, and I've read a few, and sections to realize what a rotten hand Hindus have been dealt with through this act. What adds to the absurdity is the fact that this is now a perpetual motion machine, gobbling up land, property, and government largesse with speed and stealth. 10 years ago, the Waqf owned only 400,000 acres. Now it's 800,000 acres. With every passing day, it is insatiable in its appetite, as though out to prove Dr. Ambedkar and his profound prophecy of Muslims under divine obligation to convert Dar al-Harb into Dar al-Islam. It is no longer an arcane endowment that is centuries old. It is an ever-growing mutant, having perfectly adapted to the appeasing and virtue-signaling state. The Hindus who, during the partition, fled what is now Pakistan and came to India, their property out there was promptly confiscated and either distributed to the Muslim citizenry or taken up by the government of Pakistan. Not so the case with Muslims who from India went over to Pakistan. Their property was handed over to Waqf. And as a result, the Hindu refugees who came to stay on this land are paying rent that is subject to arbitrary increases. And the injustice continues. Hindus must now beg for Waqf land to celebrate their festival, as is what happened recently in Karnataka. This when the governments of both center and state, as I said, have usurped hundreds of thousands of acres of temple land and are responsible for more than 110,000 temples losing lakhs of crores in rental incomes. There is no such act for Hindus. There is no such act for Sikhs. There is no such act for Christians. There is no such act even for Muslims in Muslim majority countries like Turkey, Sudan, Egypt. Welcome to the Islamic Republic of India. This is not our future. This is now our present.